Welcome, everybody, to the Leaders in Housing Counseling call. We're glad you're here. It's been a while since we've done one of these, and so we're back on track and glad to have you. Looks like we're going to have a very strong showing for today's call, and we have some ground to cover, so we will move right in. And the plan for the call today is Melody's going to give us the latest on what's happening and not happening in Congress. And what you should know about kind of what the next steps are and some of our thinking. I'll do just a quick update on the HUD Housing Counseling certification and the proposals we made and what the response has been so far. But most of the call will be about the CDC eviction moratorium. We have Lisa Sitkin from the National Housing Law Project. She's been very helpful in the past and is clearly an expert on these and will give us a good overview on how the CDC eviction moratorium works and what it does and doesn't do. And then we'll have two experienced voices from the field, Russell Graves from the National Foundation for Debt Management and Todd Capito from Tabor Community Services to talk about what they're practically doing given some of the shortcomings of a moratorium without a subsidy for renters in this current environment. We'll do a quick reminder on NHRC memberships and really appreciate the fact that so many groups have re-upped their memberships this year, even though I know it's been a strain for many of you. And then just to highlight, our next call will be kind of a different format, and we are bringing in Tony Neighbors, who is, and this is an extension of the conversation we did several months ago about race and housing counseling, where some of the leading Black voices in our network had a very candid and I thought helpful conversation, and there was a feeling coming from that we wanted to do more on this area. Ellie especially spent some time talking with different providers and talking with some of you about who would be good, and Tony Neighbors came up to the top as somebody who would be helpful. So we're going to devote the next leaders call to the issues around race and housing counseling. And then we will have a couple sessions after that that we'll schedule, but and we haven't quite scheduled yet, but we'll have that nailed down next week. And those will be sort of deeper dives on kind of inherent biases that many of us have, and understanding them, becoming more self-aware of them, and around institutional issues and how to manage, how to deal with some of these things organizationally or operationally. So we're kind of opening everything up to everybody, but I think going to the first one would be really helpful, and then you can pick and choose if you want to jump in on the others as well. But thanks for lots of people's contributions to this and to helping us think through what the next steps would be. Many of you participated in conversations about this, and it's been helpful. So with that note, let's get started. Oh, and just one more quick thing is it's Melody and I that are holding down the ship today. Ellie's taken a week's vacation, so she'll be back next week. All right. So with that note, let's find out what's happening in Congress. Melody?
Thank you, Bruce. Hello, everyone. We are just coming back. Congress is just coming back from a month-long August recess, as per usual. Although it's very unusual circumstances this year due to the ongoing negotiations around COVID-19 stimulus funding. I wish that we had more developments to report, but I'm sure as you heard in the news and in different portals, the House and Senate leadership are still working on a deal for the stimulus package. Talks broke down between House and Senate leadership around the final price points for the package. The House passed the HEROES Act, which was $3 trillion, and it included $100 million for housing counseling assistance. Dems have sort of talked down their final package number, going as low as $2.4 trillion, as well as offering different lengths of time for the total amount of funding. I believe that Speaker Pelosi said they're willing to do 6 months as opposed to a full year, or 3 years, as some provisions have offered. And then we found out that the Senate GOP introduced a skinny version of their original skinny bill, which obviously the House and Senate Democrats are not happy with. So talks are still going. We do know, however, that House and Senate Democrats are prioritizing stimulus funding for housing programs, including housing counseling. So as I said, the HEROES Act had $100 million for housing counseling. However, on the Senate side, they've been far more ambitious. We're still in support of the Coronavirus Housing Counseling Improvement Act, which asks for $700 million for housing counseling through NeighborWorks, similar to the National Foreclosure Mitigation Counseling Program. That would be $700 million across 3 years. And the name of the bill is escaping me, but Senator Kamala Harris also introduced a similar legislation that also includes some provisions, I believe 40% of funds, no less than 40% of funds to be used for targeted populations. We support both bills, but we're supportive of all legislation that's being put forth supporting housing counseling. The National Low Income Housing Coalition, along with several other excellent organizations, released research last month basically saying that 30 to 40 million Americans are at risk of eviction. And as you can imagine, the last thing we need in a public health crisis is homelessness increasing across the country. Affordable housing was an issue prior to the pandemic, and it's more important than ever during the pandemic. And we're happy that people in Congress are recognizing that this is not just a housing issue, but it's a public health and dignity issue. So I personally, some advocates may feel differently, but I personally feel that housing counseling will get some additional exposure and discussion going forward, simply because of the climate going on around the country around foreclosures and evictions. Bruce, you want to jump in and add something?
No, I think that sums it up well.
Thank you. Moving right along to appropriation. So even though COVID-19 is definitely taking up a lot of everyone's focus, appropriations has not stopped. So I just checked in with our House and Senate THUD connections. That would be Subcommittee Chairman Price and Ranking Member Diaz-Balart over at the House, as well as Chairwoman Collins and Ranking Member Reed over at the Senate. Just to bring back some information so it's fresh in your mind, the House THUD bill had $75 million for housing counseling. This is a $22 million increase from the final fiscal year 2020 levels of $53 million. And it's $30 million more than the White House budget proposal of $45 million. That bill now moves to the Senate. Unfortunately, there's no scheduled markups as of right now. I imagine that everyone in the Senate is very much preoccupied with COVID-19 stimulus funding, and I imagine they want to know how those talks go before they finalize decisions on fiscal year 2021 negotiations. We do know, however, that in order to prevent a shutdown, because, I mean, God, can 2020 be any worse if there was a shutdown? To prevent a shutdown this year, there's talks of a continuing resolution, or a CR, going through mid-December, or potentially farther out into 2021. There is some pushback on the CR going past 2020 on the Senate GOP side, but there's just nothing final yet. We've heard through the grapevine that negotiations for the COVID-19 stimulus bill, however, it looks like in the end, may resume next week. However, they only have a couple of weeks to actually really do negotiations because they will go back to district work week at the end of October. So they have a very, very short window to really get anything done before they return to their states and districts. So what does that mean for our advocates on the call and your own networks? We feel pretty strong in the House. The House Democrats who have majority in the House have been very much supportive of housing counseling. We feel very good with House Appropriations as well as House Financial Services, the two committees of jurisdiction for housing counseling funding and provisions. Chairwoman Maxine Waters, has been an excellent advocate for housing counseling. She originally proposed $700 million for housing counseling in the CARES Act, although the number came down to $100 million. And we feel pretty secure with our appropriations contacts in that committee. So a lot of the work to be done is really going to come down to the Senate. Excuse me, I have to drink water. Thank you. A lot of our work is really going to come down to the Senate, particularly the Senate Republicans. Has been our story for many years now. There is a lot of disagreement on the funding levels for housing counseling, not necessarily the need of housing counseling or the effectiveness of housing counseling. Now more than ever, we're able to really talk about the merits of housing counseling to a variety of audiences, but we need the Senate to know how important it is in their communities. For homeowners, for renters, for young people, new families, people at risk of or experiencing homelessness, Black and brown communities, veterans, senior citizens, persons with disabilities. They need to understand how housing counseling touches every aspect of their community and supports the housing market as well. Anything that you can provide them would be beneficial, whether that's talking points, videos, if you have it for the more media savvy folks, your annual reports, your annual reviews, showing them how COVID has affected your communities and how housing counseling is sort of helping people stay in their homes during this time, as well as to build wealth. I believe I sent out an email a week or so ago, and I'm happy to resend that email out after the call, but there was roughly 20 offices in the Senate that have great influence over the stimulus funding conversation in the Republican caucus in the Senate. That would be great if we were able to reach them. Groups in Florida, Kansas, Arkansas, Texas, a few others, they're escaping me. But I'm going to send that email out. We would love for you guys to reach out to them. You can call them even if they're in DC or they're in your districts or your states. It does not matter. They want to hear from constituents, so it's critical that your voice is heard. If you need any assistance with developing talking points, I'm happy to do that. But this is really our time. We are in a really crucial point where we could potentially get a nice, solid pot for housing counselors who are desperate for funding during these times. And the only way we can do that is a very strong presence on Capitol Hill talking about housing counseling. And if there's any questions, I'm happy to take them now over the phone or through the question function or after the presentation. Thank you.
Excellent. Good, valuable work, and really appreciate the work that people are doing out in the field. And I know that you're working with a team in Florida right now to do a meeting with Senator Rubio, and we can do more of those if where people are particularly interested. So let's move on to certification, housing counseling certification. So I think first thing to say is sort of where are we at right now? And so as of actually 2 weeks ago, so information's a little bit old, 3,169 people have passed the test, and then 2,942 are in FHA connections. So the gap of, a little bit less than 200 there. Some of those people might not be affiliated with a housing counseling agency and just took the test, or they may be that the agency has not completed their work to get into FHA commission connections. And hopefully it's more the latter, and so we'll get a little bit more up. And these numbers are 2 weeks old easily, and so it's likely that we might have picked up some more as well. How many housing counselors are out there? Well, we don't know, but there's kind of this, HUD is estimating around 4,400. So we're about 2/3 of the way there. And for those of you that follow the HUD tracking page on HUD Exchange, what they track there are the number of agencies that have at least one certified counselor, and that's at 67%, so that's 2/3, and that's 1,128 agencies. There's, probably around 1,400 or 1,500 agencies. It's a little complicated because some agencies are listed that are really just branches of others, so we're pretty far along on the path here, but I think we had a really valuable exercise on evaluating in August what needs to be done on the test. So obviously, the big news was that the deadline was pushed back 1 year to August 1, 2021, and so that took a little bit of pressure off. But on the other hand, a year is not a very long time, and also, I think one of the interesting things that's kind of bubbled up from these conversations about how to improve certification is that we should be thinking about this in the long term, not just for getting past the deadline, but for more people who will need to take the test in the future when they're entering the field. That we want to kind of bring it into a more up-to-date, more appropriate testing platform. And the other set of issues are around that there's a concern that the people who are not passing the test are often Spanish, are often not native English speakers, or they are, or we found there's certainly a number of senior experienced counselors who've been around for a while and have been having challenges passing the test, and often get quite close to the passing line, but not over the passing line. So we have had a really vibrant conversation with many of you. Over 60 people were involved in these various committees. You can see the list on the slide in front of you, but we ended up with a 4-page set of proposals. We turned that into the Office of Housing Counseling, to Danbury Carmen, to Ruth Roman, Terry Carr, and Jerry Mayer has been assigned to review and to respond, and he's kind of working through the list. And we know that some of these issues are issues they have considered in the past, and we're saying that's fine, but we'd like you to reconsider them as well. A lot of the focus was around improving the content of the test to make it more up to date to what counselors actually do, and the kind of programs that they do, and the work that they're most familiar with. Some of it is about giving people who have different learning styles some alternatives so that they can both learn and take the test. Getting better help, making it easier to take the test physically, with either in person or in doing it online virtually, and then a lot of attention was paid to the language issues. Interestingly enough, very few people actually take the Spanish version of the test, so it was less than 50. It was substantially less than 50, as I recall. That was a big surprise, and one of the early things they said was that the cost of doing these tests in other languages, if they're not getting a very strong return in Spanish. But we did also think about, can you improve the materials so that it's easier for people in language? Can you provide a glossary? Just lots of things like that. We circulated the list widely, but if you haven't seen it, let us know. We can send you a copy. And as soon as we get a response, we'll obviously put that on the Leaders in Housing Counseling list. So I think the kind of the headline news here is we're making progress, and we're much further along than we were in July. And congratulations to the many of you who've taken the test and passed it. And we're going to really do some effort this fall to try to help more people cross the finish line who have taken the test and need just to pass it. So I think that summarizes it, and I think we're ready to move to the our main topic. So this is the Center for Disease Control introduced an eviction moratorium order. So this is unusual, but badly needed, given that we were really faced with a flood of potential people being evicted for non-payment because they really didn't have the money, and because of all the problems of COVID-19, and it's a health issue because, of course, if somebody's is forced out of their housing, they then either need to crowd into somebody else's apartment, go to a shelter, and the shelters are obviously crowded, or they're on the street where it's very hard to maintain healthy conditions. So on that note, our first speaker is somebody we've had before, Lisa Sitkin, as you know, has kind of deep knowledge and perspective on all of this, on all the housing issues we work on. So we really appreciate her coming to join us again on this particular one. Welcome, Lisa.
Thank you. You can hear me okay?
Yes, you sound
okay.
Good.
So I am going to try to give an overview here of this CDC order, which is not only unusual, as Bruce said, but actually unprecedented. Nothing like this has ever issued from the CDC. And I want to just say, before I kind of dig into the details of it, that partly because it's so unprecedented and because this is obviously controversial, there are many landlords around the country who are very, very angry about this. We have already seen the first court challenge, which was brought in Georgia in federal court. No outcome or any thing to report other than the case has been filed, but I will tell you that attorneys in our network are working hard to figure out how they can get involved in that case to defend the order. But it's just something that we all need to keep in mind, that it is in certain ways somewhat vulnerable to legal challenge. It has a basis in law and everything, but we don't know, because we've never seen this before, how cases like that may come out. So while it is definitely in force now, and we hope it will stay there, it's really important that you keep up to date, and I'm sure that Bruce and others at the center will share any updates with you, but keep an eye out for what's going on in terms of challenges, so that you have the most current information about whether it's in effect or not. But assuming it stays in effect, we will talk now about what it is. We can go to that first slide. So what does the CDC order do? It is called the Temporary Halt in Residential Evictions to Prevent the Spread of COVID-19, and that title there is a link to the actual order if anyone wants to wade through the legalese and everything, or just look at the order. So you should be able to do that from this. I assume you guys are sharing the PowerPoint with folks. So in a nutshell, what it does is it prohibits a landlord or owner of a residential property or other person with a legal right to pursue eviction from evicting any covered person from the residential property where the order applies, meaning in a jurisdiction where the order applies, except for based on certain specified conduct by the tenant. I've put, you'll see a number of these terms in red because we're going to break those down since they're not necessarily self-apparent, so you can understand what the real scope is of this. But basically, it is an attempt by the CDC to put the brakes at least on a large portion of evictions that might otherwise happen in order to prevent the spread of COVID-19 by having people have to be in crowded conditions of one kind or another. It's effective from September 4th, 2020, when it was published in the Federal Register, and it goes through the end of this year, December 31, 2020. Next slide. So the type of properties covered, that residential property term, as used in the order, that means any property that is leased for residential purposes. That can include a house, any building. It does include mobile homes and land in a mobile home park or a similar dwelling that's leased for residential purposes. It does not, however, include temporary housing such as a hotel, motel, or guest house. There may be other protections locally for people in such dwellings, but the CDC order itself does not apply to people in those types of dwellings. And I know that there are, especially in California where I am, you know, more and more people actually in hotels, since that's one of the, or motels, ways that we're trying to house people who are homeless. So, you know, that's not necessarily a small exception, but it's just something to be aware of. If you're talking to folks, you need to, you know, identify what kind of housing they're in and what their, you know, lease or tenancy actually looks like. Okay, moving on. Who qualifies for protection? A covered person is a tenant or resident of one of those residential properties who has provided a sworn declaration, which we will discuss in a moment, that's what the green is for, in writing to the landlord, and it has to state 5 things. First, it has to state that the tenant has used best efforts to obtain all government assistance to help with their rent or housing. We, in the tenant advocacy community, the legal community, have been discussing what best efforts might actually mean. And we think, you know, the most reasonable understanding of it would be, you know, if someone has, for example, called 211 to try to get information about any rental assistance that's available. As many of you, I'm sure, already know, there's very little such assistance available. But there is an obligation for the tenant to make, you know, some effort to find out what's available, maybe an online search for rental assistance in your area. I didn't put it on here, but I think the National Low Income Housing Coalition has actually assembled a list of local assistance programs and funds. So looking on that website might be useful. I do not think, nor do my colleagues, that this means that somebody has to try to get on a Section 8 waiting list, for example. That seems absurd because it's not going to realistically help anyone in the short term. But there do have to be, you know, some kind of reasonable efforts made. So that's something that you'll need to counsel people if they have not done that. And it may be part of, you know, what you're doing with them is trying to find that very help, and their consulting with you may serve as their best efforts. But one way or another, the person has to be able to swear to the fact that they have, you know, tried in that regard. The person has to swear that they meet an income limit, and that can be one of the following applying to them. They expect to earn $99,000 or less in 2020. I don't think that should be hard for many people. It's doubled for a couple filing jointly. If they received a stimulus check, COVID stimulus check, you know, in this year when this has all been going on, they qualify. And another way to qualify is if they were not required to report income to the IRS for 2019. So any of those count, and as long as the person can swear to one of those, they can meet that requirement. The third is they have to be able to swear that they are unable to pay their full rent due to one of the following: either a substantial loss of household income or extraordinary medical expenses. And what that is defined as by the CDC is actually similar to a tax rule, which is that it's 7.5% or more of the person's adjusted gross income. That's not always going to be an easy number for people to calculate, but I would say that if somebody has, tens of thousands of dollars of emergency room or ambulance or something expenses, and they are making, a low or moderate income, they probably qualify. You will note, and this is a concern to me, that this does not include a financial hardship that might be tied to other types of increased expenses that people are facing, such as, childcare expenses or things like that, that we know have gone up for many households. So this is something, you'll need to talk to clients about what the changes in their income have or haven't been. Because, as I will say many times, this is a sworn declaration and they need to be able to, make these statements under penalty of perjury. So they need to fit within what's, to my mind, a little bit of a narrow definition, but it may be that, one way or another, the household has lost income or wages or something like that. And I can answer more questions about that afterwards if people have them. Next slide. The fourth item in the declaration is that they are using best efforts to pay partial rent that is as close to full rent as circumstances permit. Now, many of the people I am hearing about and talking to people about are able to pay zero rent. Others, may be able to pay some percentage of their rent. And this, was aimed obviously at making sure that people aren't just stopping paying rent when they might be able to pay some. If realistically, based on, the other household expenses and, essential expenses that the person has or the household has, they simply cannot pay even $1, then that is what is as close to full rent as circumstances permit. But again, this is something that you want to be careful about, because if they may have some discretionary income, we don't know yet the extent to which courts are going to allow landlords to challenge the facts in these declarations. So you just have to be really careful in terms of, there's no documentation that the person has to provide when they give the declaration to the landlord, but they should probably have it in their back pocket in case this is challenged, if there's any kind of litigation later about an eviction. And then they have to be able to attest to the fact that they would likely become homeless or be forced to live in close quarters, which could be a shelter or shared housing, if they were evicted. There is some other explanation in the order that makes it clear that the fact that there might be other available rental housing in the area, where somebody could move into an apartment, wouldn't count against someone in this regard, because it likely will cost as much as or more than the rent that they can't afford now. But if somebody knows kind of what they are facing afterwards, as really horrible it is to have to think that through, that's what would be kind of the substantiation of this point. As I have been sort of alluding all along, it's very important that the person signing this declaration understands what a sworn declaration is. And as I have said, that you work with them, or that they take the time to think through whether they can actually declare under penalty of perjury, meaning if there's a lie, they could be criminally prosecuted for perjury. I mean, we don't expect to see that, but These days, nothing seems beyond the pale, so I just want to emphasize this again and again because it worries me. So they need to be able to really stand behind basically what they're saying. And I think it's going to be easy, except because people are obviously, understandably, quite desperate to sort of reach for any tool available to them. You know, I think there are a lot of people who are going to you know, just sort of sign this, not casually, but, you know, without sort of stopping to understand that and thinking through each of the 5 items. So I would impress on you guys to make it clear. I'm not saying people shouldn't sign it. I'm just saying they have to sign it only if they can really attest to these things and with great care. It's not something to be taken lightly. According to the order, each adult in the household is supposed to provide a declaration. I have to say that seems ridiculous to me, but and we're not quite sure, you know, what the consequences would be if only one of the adults signs it. But to the extent possible, it would be best to follow that rule. I've given a link to where the CDC's version of the declaration form is available. We also have links to some other form declarations, including some translations that are available on our website. The stuff about this order is now at the top of our COVID resources, so you can, you know, feel free to look through the other stuff there too, but that's front and center at this point, and you can find those other form declarations. We are not advising, we've had some questions about whether people should alter any of the language in the declaration, and we pretty much advise against that, just because all of this is untested. I think it's best to stay at, you know, as close as possible to what the language is that the CDC has put out. That said, the order does say it, you know, that somebody can submit a substantially similar declaration, you know, with substantially similar information. So if for whatever reason somebody you know, writes their own up based on these 5 items and turns it in, it should be effective as well. But ideally, they would just use the form that's officially available. I also wanted to point out that you may find that there are some websites that are offering to generate the declarations after the tenant goes through and answers some questions, and then they just spit it out. And some of them actually even offer to email it to the landlord and things like that. Our best advice right now, and there's some disagreement, I will say, among, you know, lawyers about this, is that it's better to just fill out the actual forms that you can get, you know, from the CDC or through our website, rather than using those websites, because there are some glitches and some issues about additional information that they're adding in. We have not, for that reason, posted the links to those on our website, but if and when we think that you know, one or more of the websites doing that is, you know, has sort of satisfied our concerns, we'll add that there. So do check back. Next slide. So what are the actions that are prohibited? Any action by a landlord to remove or cause the removal of a covered person from a residential property that would include, as we understand it, all steps in the eviction process, including, you know, giving a notice, filing a case, moving forward with a case, you know, serving a writ to get somebody out after a case. And our view, all of this, as I've said, is, you know, untested yet, but our view is that any conduct by a landlord, you know, to threaten or intimidate or misinform the tenant to try to do a lockout, or, you know, other kind of self-help that they do, turning off utilities, things like that, that is aimed at trying to remove the tenant, would be covered under this as well. And as I say on the right here of the slide, the order does say that landlords who violate this order are subject to criminal fines and penalties, and those can go up to, I think, a year in jail, and under, I think, up to $250,000, starting at like $100,000 or something. So the idea is that there's supposed to be a stiff penalty, and the hope is that that will, you know, make landlords comply with this and be nervous. But we always expect there to be pushback, not only in the case I mentioned earlier, but, you know, in any given eviction case where the landlord might say, you know, challenge what's in the declaration, say they didn't get it, whatever it may be. You know, we'll have to see how this plays out. It's very early, obviously, in this whole process. I think I didn't
Lisa?
mention, yeah.
This is Bruce. Could I sent your slides out as an email a few moments ago. So for people that are frantically writing all this down, they have it in their in the email and through the leaders list. So
great. Yeah, and the links should be there too. Yeah,
right, exactly.
Yeah. Thank you very much. So one thing I just wanted to mention, going back to the declaration, is it has to be given in writing. We presume that providing it by email is probably fine. But whatever way it's delivered, it's really important to be able to have proof that it was delivered. So if you're mailing it, it should be done with some sort of tracking that has, you know, proof of delivery. Email, you want to save, you know, that sent email in some folder or print it out with the time and everything. But this, we expect very much that there will be challenges to whether landlords receive these at all. So it's really, really important, you know, as with when you're turning in documents to a loan servicer on a loan mod application or something like that, you want to be able to have records that show that you provided that. Eviction is still permissible in certain circumstances. So this is really focused largely on evictions for non-payment of rent. It's not necessarily limited to that, but these are the reasons that would be allowable for evictions to go on during this moratorium period, you know, regardless of the order. And that's if the tenant engages in criminal activity on the premises, threatens health or safety of other residents, damages or, you know, poses a threat of immediate and significant risk of property damage, violates public health codes, or violates another contractual obligation. So not the, obviously, payment of rent is part of the contract that you have with the landlord, but that one we're setting aside for this. Non-payment doesn't, you know, can't be the basis of eviction, but other contractual obligations that might be listed could possibly be the basis for an eviction. So it's important to keep this in mind because, you know, what we would have seen if we were rulers of the world at NHLP would just be a blanket eviction moratorium, no evictions for X, you know, period of time. And then you wouldn't have to muck around with all of these details and declarations and exceptions. But that's not what we got. This is imperfect, very imperfect in many ways. And so there are going to be evictions that can proceed. And we would expect that there will be some pretextual evictions, you know, of people who really are probably being evicted because they haven't paid rent, but the landlord will come up with excuses that fit into this list. So that's just something to be aware of, and people should understand and, you know, probably keep records and document what's actually going on at the premises so that they can contest that if they need to. Next slide. So a big additional issue, it's really more than an additional issue, it's pretty central, is how this CDC order interacts with state or local eviction protections. Our view, and again, all of this is untested, but this is the understanding that we have, is that in general, whatever is the more protective provision for a tenant would apply. So for example, in California where I am, we just passed, just days before this order came out, AB 3088. Those of you in California may be familiar with it. It is critical if you're working with tenants in California or another state or jurisdiction that has some eviction protections, particularly related to COVID. It's really critical that you understand what those are as well, and educate yourself whatever way possible. We have a lot of materials about the California one, and if people have questions about those in other jurisdictions, I am happy to try to connect you with somebody who might be able to give guidance. I may not always be successful, but I will try. But it's important to understand that there are sort of these different layers of protection, and you know, they may be different from one another. They generally don't conflict, but the question as we see it is always going to be which one gives more protection to the tenant, because the CDC order seems to be intended to set a floor for eviction protections. Like everybody who doesn't have anything else gets at least this. And then if a state or a city or county or whatever has come up with stronger protections, the tenants there should be able to benefit from those. So that means that we kind of have a patchwork of the way that this is going to play out in different jurisdictions. Again, much messier than it needed to be, I think, but that's what we've got. You know, what I would say is if you are aware, and you should find out, so if you know that there's a local or state protection that the tenant you're talking to might be covered by, you want to generally look to that first. It may or may not be stronger, but there might be pieces of it that are stronger and others. And again, you know, you can get some guidance from lawyers, legal aid in your area about that. But one of the concerns I have, and you can tell because I talked about it so much, is you know, that for people who are looking to get this protection and sign the declaration under the order, there is that penalty of perjury issue. And my feeling is that if somebody is able to get strong protection, you know, where they are under, let's say, a state law, that's going to give them, you know, as much or more than they would get under this order, they may not want to sign that declaration and have, you know, that out there. It's going to be a case-by-case kind of a decision, and I know that that's really feels probably like not useful guidance for you, because you want to be able to say everybody should just send one of these in. And it may be that in the majority of cases it does make sense for people to at least read through the declaration and see if they can do that. But there may be cases where somebody can get, as I said, the same or stronger protection without having to sign this declaration. And I would advise someone, you know, as their attorney to do that. So something to keep in mind. Another question that has come up that we've been sort of chewing on is whether the order bars evictions that are based on just a lease expiration. So somebody had a year lease and it comes up. Our view is that it does bar those evictions, but if that's the situation that somebody is in and that's the reason they're being kicked out of their place, that it's likely something that will have to get litigated, and certainly something that you know, you'll want legal assistance for. And then importantly, it's really critical to remember and to remind the tenants that you're talking to that the CDC order does not waive or forgive unpaid rent or any late fees or interest. So there was, for a time, we had the CARES Act moratorium, at least for some folks, and that did not allow the charging of late fees or interest, that one that expired back in July. This is not the same. So all of the charges that somebody is facing, you know, if they don't pay their rent on time, are going to be sitting there on the books waiting for them at the other end of this. And it's really important that people understand, you know, there's a lot of talk out there about canceling the rent, and certainly we are very, very vigorously advocating for rental assistance in Congress. But for now, what we have is just really a pause, right? So a much needed, you know, protection against the eviction in the short term, but it really doesn't solve the problem of that rent. And that's something that I think is important for a tenant, you know, considering wading into these waters to understand. It's also really important if the tenant is sort of, you know, on the sort of in that gray area where it's really a stretch to make the rent, but they could, if they had to, I don't see this as sort of any great thing to use unless you absolutely, absolutely have to. So that's the advice I would be giving people. And I would be happy to answer questions.
Hi, so we have a lot of questions,
Sure.
a lot. And I just want to tell people that we're close to 2 o'clock, but we will be going over for our other two presenters. So please just stick around. It's a very robust conversation, I understand, and we hope to work through all the questions. First question, does the sworn declaration need to be notarized?
No.
Okay. For landlords accepting partial payments, is this still allowed, or are they still covered under the moratorium?
If the landlord is accepting a partial payment and the tenant has some sort of agreement with them, presumably the landlord's not planning to evict them. If the landlord and the tenant have not really communicated about it, but they have just accepted the partial payments and not, you know, taken any action, since there is still a risk of that, I mean, what I would say is, you know, talk to the landlord if at all possible to figure out, you know, if they're going to hold off. But, you know, certainly if somebody is making partial payments, really whether they're being accepted by the landlord or not, you know, some landlords will refuse that. They, you know, can use this, and they obviously can attest to the fact that they're, you know, making the partial payment in good faith or best efforts, whatever the terms are there. So yes, I mean, the short answer, I think, to what the question was is yes, they would be protected as well.
Thank you. What's the cost of the perjury penalty?
Huh. I don't know. I know that Maxine Waters has been railing about this because she doesn't like that that's in there, and I don't like it either. So she has some information, I believe, on her website. She put out a press release, but I don't remember the specifics. I'd be happy to send an email to Bruce and Melody after this and follow up.
Thank you. What about individuals who share a house? So let's say there's I lived in DC for 7 years. So let's say in a row home, there are 4 separate tenants with 4, you know, they all share a lease. And one person's employed and can pay their portion, but the full rent can't be covered by themselves. What are their options under the moratorium?
I would say, so they're on the lease together, you're saying?
Yes, and one person can pay, but another can't. Are they all protected?
That's a great question. So this goes to the weird thing of them requiring everybody to submit this. I think that they would all be protected, but the person who can pay their part of the rent should be paying it, and that would allow all of them to say, you know, I'm making best efforts to pay as close to the full rent as possible, and that's, you know, I mean, that person would have to be willing to do that, but they should do it. And then all 4 of them should be able to attest to that. Yes, that is my answer.
Thank you. Does the eviction process stop once the tenant submits the declaration?
It should.
Thank you.
Whether the landlord will try to proceed or not is another question, but yes, that it should. And I should have said, the declaration can be given at any time. The tenant does not have to wait for the landlord to have taken action. They can deliver it to them tomorrow if they want, but with all my caveats about, you know, taking care and being cautious in terms of filling it out, but they don't have to wait for any action. And if action has been taken, it should stop things at that point.
Thank you. Who enforces the penalties? I think you said you're not sure.
Against the landlords?
Yes, or tenants.
So against the tenants, our concern would be if this came to court and something was challenged and it came out that something was not true or accurate, that I think it's within the power of the court. I'm not sure. I guess a prosecutor there would have to decide. I mean, I hope that it's a small risk that we're not really going to see those, but we just don't know. And as I said, these are strange times. So, but in terms of the landlords, those penalties and the enforcement, CDC has empowered local and state authorities, so like attorney generals and DAs, would be able to enforce this, as well as federal authorities, officials.
Thank you. Can landlords decide to not renew or lease or evict during this time?
So that was this question on this final slide. Does the order bar evictions based on a lease expiration? So our view, as I said, is that there's a really strong argument to be made that the way this is all constructed, that simply, you know, having come to the end of your lease and not having it renewed, that should not be a basis for eviction during the period of the moratorium. I mean, it could be later, you know, on January 2nd or something, but we don't know that for sure. But I would say that somebody who is in that situation, it's not that the landlord necessarily has a duty to renew the lease. It's more about whether they can evict a person whose lease has come to an end, which they shouldn't be able to.
Got it. So just to clarify, someone had a question about the New York moratorium that ends on October 1st. Does the CDC moratorium supersede that?
So once the New York moratorium ends, the CDC order will certainly be in effect. Until it ends, our best view, as I said, is that whichever is stronger is the one that's in force. And if parts of the New York one are stronger than the CDC or vice versa, the tenant should get the benefit of all of the strongest provisions in both or either. So I know that's complicated, but what we're saying is if you put them side by side and pick out all the strongest protections, that's what a tenant should have while the New York one is still in force.
Thank you. Going through, what about residents who have verbal agreements with their landlords? Would it cover them?
Yes.
So I know you said that the tenant can send the declaration at any time. What is the deadline for them sending a declaration?
Well, it's not going to do them much good if they send it on December 29th. So, I mean, they can send it anytime. I mean, they could send one on January 2nd. It's not going to have any effect, though. So basically December 31st, but you're not going to get, you know, you're going to get a few hours of protection at that point.
Thank you. Has there been any discussion on future evictions on credit reports? We're getting a lot of credit report questions. I'm going to ask two. Are there any discussion on future evictions going on credit reports, or if an eviction should, or eviction that has already happened during the pandemic? That's the first one. And then the second one is all the roommates who share a lease, but one cannot pay during this time, will they all receive a negative credit impact?
In general, evictions, unless they go to judgment, so just the filing of an eviction itself, that is not reported on credit reporting. However, there are other, you know, screening services and everything that scrape that information from court dockets, and landlords and tenant screening agencies do use that, but that's different from a credit report. In terms of whether evictions, you know, just the filing of an eviction is going to show up on credit reports, I don't think so. But, you know, if the unpaid rent goes to a debt collector, for example, then that can show up. So it sort of depends on what direction things take. I will say that I know in our new law in California, AB 3088, there is a provision that masks eviction cases, meaning that it's not supposed to be public information that could then be used in tenant screening or, you know, on credit reports or anything, for the period of time that's covered there, which I think is, I can't remember, it has some different effective period, but definitely for the next several months and since the beginning of the pandemic. So other states may have similar kind of masking, the idea being, you know, that any eviction that occurred during this period of time of the pandemic is not really the fault of the tenant, and they shouldn't, have that on their record or something. So again, it's patchwork because it's going to depend on, what's going on in your state in that regard. It's something we would have loved to see the federal government do all across the country, but it hasn't happened. For the 4 people on the lease, so none of it, just in terms of the filing of an eviction case, is necessarily going to show up on credit reports. But if everybody's name is on the lease and the lease is not being paid in full, I would presume that any kind of reporting or showing up on tenant screening reports and things like that would probably happen for everybody on that lease, because usually they're jointly liable for the rent, but that would depend on the particular lease as well.
So let's jump in for a moment here and bring in our other 2 guests. We're going to pause the questions and we can come back to them if you have more time, Lisa. But wanted to make sure before we start losing people that we get our 2 practitioners to talk a little bit about what they're doing and telling people. So.
Yes, and for those asking, this presentation is being recorded. The full recording will be in our media library on our website, hsgcenter.org, by tomorrow afternoon, if not this afternoon.
Okay, so let's next slide it. And so we have Russell Graves, who has been on before and appreciated, who is the head of the National Foundation for Debt Management, and does many, many activities. One of them is working with renters in this situation. So Russell, what's your strategy on managing these?
Okay. Thank you all for staying and listening. We've got some things we're talking about and how our client action plans and what we're telling our clients has evolved over time. I am Russell Graves. I'm the Executive Director of National Foundation for Debt Management. Our area of practice is in New Jersey and Florida predominantly, and we assist folks there. If we could get the next slide. The novel coronavirus pandemic has affected many aspects of our lives and interactions, and the effect on renters is most egregious, and it has, made addressing their problems all the more important. Further, as the pandemic evolves, we've had to adjust our rental counseling to meet the changing needs of these renters. Unfortunately, the political overlay of the crisis has been exacerbated by the election, evidenced by the CDC eviction moratorium. The moratorium is little more than an election promise. No, it's a little more than that, but unfortunately, it's an incomplete solution. It does not solve the underlying problem. It just pushes the problem past the election. At NFDM, we have had to change the way we are meeting our clients' needs. While we continue to help clients get the short-term rental assistance, the homeless avoidance emergency help, all the different grants and different helps that are available, we now have to work as if there is not going to be a second round of CARES, HEROES, HEALS, skinny heels, whatever, and the second stimulus may not happen. We've had to prepare our clients for the worst case scenario. At the same time, we're working to prevent the worst case scenario. If we can move to the next slide. We're trying to really set up our clients for long-term success. Without the help of, National Housing Law Project is working for the National Low Income Housing Coalition, and those folks who are trying to get Congress to give us the help we need, we really have to prepare our clients for long-term success, or at least not homelessness. We are doing everything in our power to get word out to on the CDC eviction moratorium and get the form into the renter's hands, so if they need to use it, they have it. And we're encouraging everybody on the call to, really tell their clientele, their base, that this is out there. Put it out on social media. I don't think a lot of people know about this one as much as other ones because it's a little bit in the background. one program we are participating in New Jersey is called the Landlord-Tenant Court Mediation Program. And it's a non-binding program that brings tenants and landlords together on Zoom to see if they can work out a solution. The judges in New Jersey are really encouraging the landlords to make concessions, or they'll have to wait very long lines when the court reopens for new cases, and equally long lines when the sheriff has to actually evict. So we're helping clients get all the information available on available resources, benefits, and you know, some of those benefits are in fact stackable, which was good. We can move to the next one. So our first action with our client is communication, okay? Communicate with their landlords. All tenants that we've talked to have been receiving emails, texts, and notices. I mean, landlords are getting a little anxious. And our recommendation is to answer them. Mom and pop landlords make up about 49% of the rental market. And many of them need the income from the property to pay their own bills and taxes. So we're telling people to talk openly with their landlord about their situation and understand landlords are frustrated too. And, you know, if that's the case, we actually tell our clients to get us involved with the conversation. We don't have any legal standing or anything else, but we can certainly help our tenants communicate with their landlords. On the next page, we're going to talk about payment plans, okay? See if your landlord will accept a payment plan or some kind of reduced payment. As we found out, it's part of what you're attesting to if you want to take this moratorium. And frankly, the tenants still owe the money. But, you know, there are some landlords who have agreed to accept reduced payments. And, you know, one small payment, you know, these smaller payments take a lot of the pressure off. They show good faith. And, you know, but one caveat is don't make any promises you can't keep. Don't tell them you're going to pay more than you can, because that just, you know, breaks the chain for most landlords. Tell them, you know, if you get a stimulus check, if you get the extra FEMA $300 a week, which really won't last for very long, that you can pay a little more, but you can't give them all your money. On the next slide, we're going to see that we're also telling clients that you want to hope for the best, but prepare for the worst. You get your credit report in better shape in case you need to look for a new place to rent. You know, while an eviction due to coronavirus is a serious setback, it is a one-time, non-repeatable, at least we hope, event that could be overlooked like a medical on credit reports now. You know, and small changes in a credit report sometimes can yield good results. You know, there's the possibility. The next thing we're telling our clients on the next slide is take advantage of all the public benefits. There's all different lists that we have been able to find, a number of portals. Many clients are new to the system, new to receiving public benefits, so they may not know where to go. So we're using that benefits checkup, the one people use for reverse mortgage. That's just one place we're looking. In addition, we're looking at the state portals. New Jersey has one through the Department of Community Affairs. It tells you if you're eligible to receive benefits. One of the important things we also talk about is utility assistance. Keeping your utilities on is key to not being evicted, okay? Some states you can evict you if the utilities are shut off, and that's not covered under the eviction moratorium. Utility assistance is available in most areas and will help you from being shut off. You know, it's important to reach out to them. On the next slide, the next thing we're telling our clients is get legal aid. I'm not a lawyer. I don't play one on TV. And housing counselors, while they can help in many situations, they have to watch out for the unauthorized practice of law. We do a lot of walking along that line in our practice, and we have to make sure we don't cross it. And frankly, getting legal aid to our clients is the best thing we can do when they're facing eviction or anything like that, is to just get it out there, get the help we need, especially if it's an illegal eviction, a self-help eviction, or locking out. Those are the time you need a lawyer. The next slide, I was hesitant to put this in, but one of the things we're trying to think about is how we're going to help clients when this is over. And it's hard to figure out. But bankruptcy may be the only way that tenants can put the financial ravages of the coronavirus behind them. If we look at a tenant with 8 months rent of $1,000 a month, that's $8,000 by the end of the year. Trying to pay the regular rent of $1,000 plus part of that $8,000 is going to be prohibitive for most of our clients. So we are considering talking about bankruptcy. Frank talked about bankruptcy when this is all over, for people once they've settled into a new place, or we've gotten them into a position where the homelessness is avoided, but we need to work on their credit. And one bump due to no fault of their own, the coronavirus, should not hold anybody back. And it may be the fresh start that some of these tenants need. I would love to hear from anybody else who has some other ideas, but right now, 5, 6, 7 months of not paying your rent and having those kind of judgments on your credit report. We've dealt with a little over 400 clients in the last couple months, and looking at their credit reports to try to get them better, I find that the clients that we see have some credit issues already. And I think this is going to be the one that breaks the camel's back as far as their credit report goes. And maybe they need a fresh start, but bankruptcy is about timing. You don't want to do it when you just have 1 or 2 things on there. You want to do it when you can move forward from it. Okay, next slide. Like I said, I'm Russell Graves. We have this stuff on our website at cc-bc.com, rental counseling. I've done a couple of these things and they continue to evolve, and I'll keep everybody updated. I thank you all for listening to me.
Thanks so much, Russell. So we also have a second practitioner, Todd Capito from Tabor Services, and we should. So Todd also has his own thoughts about what they're actually doing in the field right now. So Todd, if can we get you on and explain what you're doing?
Sure. Can you hear me?
Yes.
All right. Yeah, I didn't put any slides together for today. I apologize. I sent the email over to Bruce, and probably should have followed up with that. But I'm going to take a little bit different view on this. Not so much a view, just I don't want to duplicate what's already been said. So I'm going to pick and choose some of the things that we're doing in the Lancaster County area in Pennsylvania. So not too far away from New Jersey there with Russell. We started an eviction prevention program back in 2018. Tabor's been around for 52 years. We did have an eviction prevention program earlier on, and it got defunded because of it was being funded mostly by the Homeless Coalition, and it's hard to dictate whether or not someone's going to be homeless just because they're being evicted. So some of that monies were focused elsewhere. But in 2018, we started looking at this is definitely a need within our community. Sure, it's not any different in other communities, but it kind of set us up for what is happening now in 2020. In the interim, in 2019, we had formed a coalition called the Eviction Prevention Network. That started with 6 organizations, and now it's over 30 throughout our county. Some of them work outside of our county, some are just in the county. But again, that was the basis to be able to get resources into the hands that need it. And I would say what we had to shift gears with was we're not really doing eviction prevention as much as we're doing rental relief now. We were able to get funds through the rental relief program, which is a state-funded program in Pennsylvania that was using CARES funds that was submitted to Pennsylvania. Right now, every county has its own way to get the funding out to the actual clients that are in need. They have to show a reduction in income of 30% or more, or they have to be on unemployment. Those are the main tenets of it. In our county alone, we've seen about 500 applications. We're doing that in a partnership with our redevelopment authority in Lancaster County. So 500 doesn't sound like a lot, but if 67 counties and we all see 500 or more, now we're talking 30 to 40,000 clients depending on the county. So it's probably something that's going to definitely grow. But the problem was, like other programs, like the CDC thing, it's short term and it doesn't cover everything. So we're trying to work within those parameters. So that's one thing that's really kind of set us up. We also put together a resource guide that was county specific, but a lot of the pages, I'm sure anyone here could use that in your local area to go over how clients should be acting and reacting with their landlords. One of the biggest things that we do is make sure that the client and the landlord are being proactive. If you're a landlord right now, which I was for the last 10 years, I just sold my last property last year before this all happened, but I would want to be proactive and be getting those type of resource guides into the hands of my tenants, even if they don't have a problem. And vice versa, if we're trying to hand it out to as many clients, the tenants themselves, to make sure that they have them as well. We've also formed a pretty good relationship with our district magistrates and also the local bar association. So we have advertising flyers that are at all the magistrates' office. They've been sent to most, if not all, the attorneys in our bar association, and we have local Mid-Penn Legal Services that they have these things as well to be able to assist clients through the legal process that a lot of these things can be. And the magistrates especially have been very, very open, because obviously they don't want to see this backlog of folks as it continues to grow since March. It opened up, we had a short window when our moratorium ended at the end of August. And then we had the short window here until the CDC one started back up early September. So they did see some of those clients during that process. The other thing is we try to make sure that we're advertising this to landlords and property managers, that this is a program that makes property managers and landlords whole, as well as the tenant. I know a lot of times the resources are focused on the tenant side, but I think it goes a long way to get the landlords and property managers to work with us when they know that this is a program that's for them too. It's not just one-sided. It's benefiting all parties if we can get together and work through this. Right now, 2-on-1 has been, I know it got brought up earlier, but 2-on-1 has been a great resource. They're being able to do the intake for a lot of the programming that we do throughout the county now. And a great thing, and again, Russell brought this up, but now we're able to stack funding. We were able to receive funding through CDBG, HUD grants, ESG, the emergency HUD grants, and some local foundations, United Way, and some other larger corporations. And now we can stack that. So some of it's good for clients that are under 30% AMI. Some are good between 30 and 80% AMI. And some, because right now there's a lot of folks over 80 or even 100% AMI, we have funding that's dictated just for them, and we stack each one of those. On top of that, the rental relief program for the state is good for 6 months worth of rent. The other programs now can go another 6 months. So a client that goes through this RRP program for rental relief could get up to 6 months. And then if it was a continued issue, they could get an additional 6 months worth of rental assistance. So this has been huge. The only problem, obviously, that I foresee going forward, especially when the moratorium is lifted, that we're going to run out of money fairly quickly. We've already been exhausting certain pools of funding, but that's basically where we're at, where we're trying to make it that there's a coalition within our area, within our county, and also within the state, to be able to pool these funds together and share those funds. So that's basically where we're at right now. If there's any questions for myself, I know with Russell as well, I'm open to those.
Excellent. Thanks so much, Todd. Good. And let's open up questions and certainly make them available to everybody that you think. Melody.
Yes. Let's see. Okay, to Russell. Bruce, could you mute your line? I'm hearing myself echo. Thank you. To Russell, besides legal aid, which can already be overwhelming, where's a place people can access free legal services for bankruptcy, not for people who are losing extra assets, but people who are facing or at risk of homelessness?
Legal aid is the only legal advice we give out. We do access benefits at the local homelessness avoidance agencies that are across the states, and any other people who are using, got CARES Act funding, we end up putting them through to there. But as far as the legal stuff, we go straight to the lawyers themselves.
Thank you. This one's also for you, Russell. Forgive me. If you know that the utilities are going to get cut off and you're on the Section 8 voucher program, we're being told that you will lose your subsidy as a unit because it will be considered unsanitary for living. Have you heard anything about this, and what is the risk for some renters on this?
Yes, it's affecting all renters. If you lose your utilities, you may lose your ability to live there because it's unsanitary. It's unfit to live. In addition, it definitely affects the Section 8 rent recipients even more because they lose their Section 8, which could be even worse. So trying to get the assistance helps. The assistance is what you need so you don't lose your utilities.
Thank you. This could be for the whole panel. What about those who lost their rental properties to fire, which is pretty much all of the West Coast right now? What would help them in terms of, if anything, this eviction moratorium of legal aid? Anyone?
I really don't know how that would help anybody. If the house isn't there, you've got to find new places to live. Unfortunately.
Thank you for that, and good luck to the person who informed us of that. Can you evict during overcrowding at this time? Would it be considered a violation of the moratorium? Lisa, that might be for you. Lisa?
Yeah, sorry. I'm not sure what it means. Evict for overcrowding. So theoretically, that might fit into one of those permissible bases for eviction during the moratorium if there is a true, public health. I mean, if there's like an actual violation of a public health regulation or a concern that I included that list of things, and the landlord might try to fit overcrowding into one or more those categories, and then you know, a legal aid attorney hopefully would be involved and would, you know, argue that it doesn't fit for whatever reasons. It's kind of going to depend on the particular circumstances and how bad the overcrowding is in connection with, you know, health and safety concerns.
Thank you.
Yeah, our state
oh,
law,
sorry, go on.
our state law, okay, our state law will actually, when I talk to the landlord-tenant judges, they are really keying into emergency situations only. They don't want the landlord to use any excuse in the book. So we are obviously recommending legal aid.
Thank you. What about evictions that have begun prior to the CDC moratorium that includes non-payment of rent, but also other lease violations such as endangering health and safety of other tenants? Can that eviction go forward with only the other violations and not non-payment?
In the same way, you know, that we were answering the prior question, it possibly could, but that's really a place where you want to have, you know, a legal advocate involved to be able to make the case that, as is often going on these days, that the other supposed violations are probably being used as a pretext, and that it's really about the non-payment. But it may be that the case is allowed to move forward because those other grounds are alleged.
Thank you. Does the CDC moratorium just cover the entire pandemic or specific months?
It covers from when it went into effect on September 4th through December 31st, 2020.
Okay, so evictions that, if the evictions that are filed prior to the September 4th start can still go through?
No, so there shouldn't be further action taken by any landlord, even on a pending case, if it was filed beforehand and it's barred by the order. So let's say it's, you know, for non-payment of rent, or, you know, at the end of a lease or something like that. The landlord would be violating the order if they, you know, for example, filed something to move the case forward.
Thank you. People are asking a lot of questions about clarification. So people can file, they just can't have judgments of eviction between September 4th through the end of the year.
No, they should not be filing new cases either.
No, got you. Thank you. What if a landlord is renting to a tenant illegally in their basement or another house, or et cetera? What are their protections there under the moratorium?
Well, I mean, others on the call may have seen these situations, but, you know, that landlord is going to have some trouble using the eviction process anyway, I would think. But, you know, if the person is paying rent and living there in the residence, there's nothing in the order that really would exclude them. So I would say they should still be covered, but there are probably going to be other issues that arise. And as with so many of these questions, go to legal aid. Or to legal services. I understand that sometimes we're dealing with, you know, undocumented folks too. So there are some legal services organizations that are not LSC restricted. So that's where they would want to go. Thank you.
Those who were covered under the CARES Act moratorium and have already gone to court, does the CDC moratorium cover them as well?
So it's going to depend where things are in the process, and it's, you know, different in different states how the eviction process actually works. So what I'm familiar with in California is, you know, there would be the case gets filed. There's some kind of adjudication by the court, a judgment gets entered, and then the after that, the landlord would seek what's called a writ of execution, and then that would go to the sheriff to post. Anything that the landlord is doing, any steps they're taking to move that process forward, no matter where it is along the way, is prohibited. That's my understanding. It's prohibited for the landlord, but what we're concerned about is that it's not clear if, you know, a writ of execution, for example, in California has already gone to the sheriff's office. It's not clear that the sheriff is forbidden by the order from carrying that out. So it's going to be very dependent on exactly who's driving the car at that point in the process. But anything that the landlord gets involved in, you know, making a phone call, reminding them, serving documents, whatever it may be, that would be prohibited, because that would be part of moving toward removing the person.
Thank you. What about those who are renting out land? So we have a scenario where an individual owns a condo with an attached land lease. So they don't have a mortgage, but they do have a landlord and annual rent, similar to those on mobile home park residences who own the house outright. If they're unable to pay the land lease in full, I imagine the owner will move forward with evicting them. Is that covered under the moratorium at all?
It should be.
Okay. Well, great. Let me see. 1 second, sorry. Could someone, I believe this was you, Lisa, could you explain what the AB regulation was?
Oh, I'm sorry. So in California, so this may not be relevant to folks outside of California, but in California, at the last second of the legislative session here, our legislature passed, and the governor went ahead and signed right that night, I think it was August 31st, what's called AB 3088. That was the name of the bill, or the number of the bill, AB 3088. And it is our, at least short-term, COVID-19 eviction protection relief act. I can't remember what they called it. So there are things where it overlaps with the CDC order and is slightly different, in some ways more protective, in some ways less. So we have also, I think, some materials that talk about the interaction between those two. I'm not sure if those are posted yet, but we've done a lot of thinking about that for the California law.
Thank you. Someone asked this, and I can pretty much answer, the renting illegally versus renting to people who may not be in the country legally. Yes, essentially, it would be, well, I'll let the housing legal expert explain this. But I think it goes to a larger question of what's the course of action for those who may be undocumented in a situation where they're being evicted, or they don't know details of the moratorium or their protections under the law.
Well, I mean, we would hope that there are groups doing outreach to, you know, educate people and let them know that this is there. There's nothing in the order that makes any distinction between regarding immigration status. So, you know, somebody who's a tenant who happens to be undocumented should have all of the protection that somebody who's documented has. I recognize, though, that there are often other barriers in terms of language and getting legal assistance and things like that. But in terms of whether the, you know, the order applies to them, it does.
Thank you. Those are all of our questions.
Great.
Well, thank you very much, everybody, to Todd, Russell, and Lisa. This has been terrific, and we've got a really strong showing still today, so a lot of people hung in there. We're going to close out really quickly with just a reminder to join NHRC if you haven't already. They've had a really good year. We really appreciate the support, and especially knowing that so many of you have renewed your membership dues, and we know that it's a tough time. So certainly if you've got the room and you haven't joined yet, please do that. We do have a discount for the Savvy, the student loan service, which is very good. And we also have the discount on credit reports through CoreLogic Credco, which many people are taking advantage of and which has worked quite well. So keep us in mind. And then our next call will be next Thursday. Ellie will be back. Nice. We'll be the three of us back again. And we'll have Tony Neighbors, who is, this is a follow-up on the call that we did a couple months ago about race and housing counseling. And the whole question's about how do we address the kinds of anti-racism issues and institutional issues in our work with our clients. And so we brought him in on the recommendation of some of you. He has been thoughtful about this, and we'll do a broad presentation around race issues for us on the next leaders call, and we'll follow that up with two smaller sessions, one on institutional bias or nature of the bias that we carry with us, and another one about how to implement changes around these issues inside organizations. So we're hoping that both of those, all three of them, will be useful to you. Certainly pick and choose, though the starting point is to take the first one on this coming Thursday, and we'll schedule the other two shortly thereafter. But besides that, thanks everybody for your participation, and we will talk with you next Thursday.